Hey, how's it going? We're in Loper Bright, Kagan's Dissent, page 9 in the slip opinion. Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. I'm sharing my screen. Feel free to call me Sharon. I got my Shetland wool sweater on this morning because it's pretty cold. I know that that makes people laugh, but it got down to the 50s here in Southern California. For one, Kagan says on page 9 of the slip opinion, 603 U.S. reports, we don't know the page yet. For one, because agencies often know things about a statute's subject matter that courts could not hope to. The point is especially stark when the statute is of a scientific or technical nature. Agencies are staffed with experts in the field who can bring their training and knowledge to bear on open statutory questions. Let me stop right there. I know you're thinking, oh my gosh, here he's going and stopping again and commenting. Well, that's kind of the point of this podcast is we're we're making comments as we go along, right? So let's take agencies are staffed with experts in the field who bring their training and knowledge to bear on open statutory questions. Well, there's a process for that in Congress, and the process is you have testimony in the House and in the Senate. You have testimony, expert testimony, that the legislators can draw from in the congressional record and to inform their legislative debates prior to lawmaking done in the Congress. That's how it's designed in the Constitution. And I know you're thinking, oh my gosh, here he goes talking about the Constitution again. All legislative powers herein granted shall be vested in a Congress of the United States, comma, which shall consist of a Senate and a House of Representatives. That's Section 1 of Article 1 of the U.S. Constitution. There's nothing in there about expertise as a requirement for being a lawmaker, and it's certainly not sufficient for being a lawmaker, right? So, so why would you say that the experts are the ones creating statutory content instead of Congress? And that's what she's saying, instead of Congress. That's her policy preference here. Consider, for example, the first bulleted case above. When does an alpha amino acid polymer qualify as a protein? I don't know many judges who would feel confident resolving that issue. First question, what even is an alpha amino acid polymer? But the FDA likely has scores of scientists on staff who can think intelligently about it and maybe even collaborate with each other on finer points and arrive at a sensible answer. Okay, I'm going to stop right there again. When does an alpha amino polymer qualify as a protein? All right, well, it like I've said before, if Congress doesn't answer that question because they have the legislative power vested by the Constitution, it's in Congress. Well, why would you say that there should be a law about it at all under our Constitution? If it's too complicated for Congress to legislate, they have no business legislating about it. Am I right or am I right? Or am I right or am I right or am I right? She says judges are not confident. All right. Well, great. We don't have judges making law. That's fine. That's fine with me. Judges are not lawmakers under our system, right? Now she says, but the FDA. Well, hold on a second. What branch is the FDA in? It's in the executive branch. Let's take a look at the Article 2 power that creates the executive branch. It says the executive power shall be vested in a president of the United States of America. He. The very next word is he. It's singular. There's one person vested with the executive power in our system of government, American constitutional separation of powers, the purpose of which is to protect individual liberty. All right. The FDA would be under the president. So what she's really saying here is she's saying, but the president, that's what she's saying. But the president, FDA, switch FDA for president, because she's talking about different branches of government. And when she's talking about judges, she's talking about Article 3. Let's take a look at Article 3. Very next article, Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Well, that's an Article 3 issue. Okay. So judges are not supposed to make law. They have the judicial power, not the legislative power, but the judicial power. Article 2, the president has the executive power. Article 1, Congress has all legislative powers herein granted. The FDA has no, it's first of all, what article is this? This is an Article 2 institution. The FDA is an executive branch institution underneath the president. I think it's in, is it Health and Human Services? That's an executive branch. The FDA has, what she's saying is the president has the executive branch, the executive power under the president, has scores of scientists on staff who are intelligent and they can collaborate. Well, Congress certainly knows this, which is why Congress subpoenas FDA scientists and other people to come testify to inform lawmaking. Right? Right. But that's before the law is made. The lawmaking is done not by the FDA, but by Congress. The FDA is not the source of law. They may be experts, they may be intelligent, but that's not the constitutional authority for law. Congress is a Senate and a House of Representatives. So there's all sorts of problems here. I'm pointing out the problems. Or take the perhaps more accessible sounding second case involving the Endangered Species Act. Deciding when one squirrel population is distinct from another and thus warrants protection requires knowing about species more than it does about consulting a dictionary. how much variation of what kind, geographic, genetic, morphological, or behavioral, should be required. Remember, she's going through these bullet points that we covered last time. Remember that? So she's talking about this bullet point right here, which was on page 5 at the bottom of the slip opinion. Go back to page 9. How much variation? Okay, well, that's an interesting question. If Congress cannot decide that, there is no law about that. And that's not a reductio ad absurdum. That's reductio ad realitum, that there is no law there in our system of government. And if it's that complicated, why are we legislating about it in the first place? If it's that complicated. To me, it doesn't sound like that complicated of a question to me. Seem like Congress could very easily come up with an answer to that. She says that a court could muddle through the issue and announce a result. Well, Congress could do the same thing. And if Congress hasn't done that, what makes you think there is an answer to it in law? You know, she wants there to be an answer to it somewhere in the statute, but there isn't. So she says Chevron is great because she's defending Chevron because Chevron is the court getting involved and saying the executive branch now makes laws because Congress didn't there. And that just doesn't follow. It just doesn't follow. But wouldn't the Fish and Wildlife Service, with all its specialized expertise, do a better job of the task of saying what, in the context of species protection, the open-ended term distinct means? Well, again, what we would say is if there has to be a law about this, and there's only one branch that can create that law, it's in Article 1, Section 1. I think I've said this like 20 times now. Um, then those so-called experts could be subpoenaed to come before Congress to testify, get it in the congressional record. Then it could be debated. The merits of those positions could be debated. Probably not all the experts agree. You got the novice to expert problem. Alvin Goldman, anyone? 1980, 81, social epistemology, no? Green cover, library, philosophy section. Yeah, sometimes experts disagree, and so it becomes a political question, a political answer, and that's why you have the Constitution vesting legislative power, all legislative power here and granted in a Congress, not in the executive branch. That's not who has the legislative power. She's saying the court gets to decide that it's the legislative, that's the executive branch that has that power. That's what she's saying here. And I think maybe what she's saying too, although she's trying not to say it because it would be uncouth, but I think she's saying that her policy preference as a judge, as a federal justice of the Supreme Court, is that we ditch the Constitution because it's impractical. I think that's what she's saying. And I'm saying maybe what's impractical is that we're expecting Congress, we're expecting there to be laws about all these things. But why think that? I mean, maybe we should re-examine our expectation that the government regulate everything under the sun. Maybe we need to re-examine that. One idea behind the Chevron presumption is that Congress, the same Congress that charged the same that service with implementing the act, would answer that question with a resounding yes, page 10 at the top. The second idea is that Congress would value the agency's experience with how a complex regulatory regime functions and with what is needed to make it effective. Well, again, we have, the assumption that there should be a complex regulatory regime. That's her policy preference, clearly. And so she wants to protect that with practicalities, and she's willing to ditch the Constitution in order to do that. Um, that sounds like how this is how it's reading to me. Feel free to push back on this in the comments. I'd love to hear what you have to say. Let's stick with squirrels for a moment, except broaden the lens. In construing a term like distinct in a case about squirrels, talk about wanting to regulate everything under the sun. We're talking about squirrels here, guys. Um, maybe that's the reductio ad absurdum. According to the founders, they would be like, wow, you're spilling a lot of ink just about squirrels. Hmm. All right. In construing a term like distinct in a case about squirrels, the service likely would benefit from its historical familiarity with how the term has covered the population segments of other species. Just as a common law court makes better decisions as it sees multiple variations on a theme, an agency's construction of a statutory term benefits from its unique exposure to all the related ways the term comes into play. Or consider, for another way, regulatory familiarity matters, the example of adjusting Medicare reimbursements for geographic wage differences. Hmm. According to a dictionary, the term geographic area could be as large as a multi-state region or as small as a census tract. Yeah, yeah, it's vague. It's not ambiguous, it's vague. Okay. We've talked about that on the podcast, that difference. How to choose. It would make sense to gather hard information about what reimbursement levels each approach will produce to explore the ease of administering each on a nationwide basis, to survey how regulators have dealt with similar questions in the past, and to confer with the hospitals themselves about what makes sense. Wait, who's conferring? Who's conferring? Notice that I think she's pretty much um, excluded Congress from this. I don't know why. Maybe. Congress knows the Department of Health and Human Services can do all those things, and the courts cannot. But Justice Kagan, Congress also knows that it can do all those things. Congress gathers hard information. Congress uh, surveys regulators. Well, first of all, isn't Congress a regulator? I mean, let me look at the Constitution again. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Yeah, that sounds regulatory to me. Um, I just wanted to check and see if it was still there. Congress knows that it itself can do those things. And I mean, courts can do those things too by taking testimony. The courts are wonderful fact finders. The issue is not competence in finding facts. That's not really the issue. The more complex things get, you're going to have problems. the question is, are we sticking with the Constitution or not? And why would we stick with the Constitution? Well, because it's naive to think that this is just purely about expertise. Experts disagree with each other all the time. And it turns out their disagreements sometimes have something to do with nothing involving the expertise at issue, but political matters that they differ on. And I think this is pretty widely known. If there are experts that are skeptical of regulatory efforts to curb uh, so-called global warming or to treat carbon dioxide as a pollutant, like a greenhouse gas as a pollutant, as as many want to do and have wanted to do since 2007. Well, um, that if you accept, if you're an expert and you express doubt about that based on your expertise, more than likely you'll be attacked for political reasons. And I think there's something interesting about the reason why. It's because everybody understands that this is not simply about expertise. There are political differences as well. And the framers of the Constitution were not naive. They knew this and they embraced it. And they just said, this is just the way it is. This is not going away. We have to be aware and not naive that expertise often conceals politics. One political strategy to get your policy preference in is to rhetorically play it up as if it's only about expertise or only about morality or whatever you want to do. You use the valence language, which is a political tactic. Uh, I mean, you try to when Democrats call Republicans racist or fascists, that's not based on expertise of those terms. In fact, it's usually uh, in direct conflict with the ordinary historic meaning of those terms. The move there politically is to find valence language, language of criminality. In our culture, you're either a criminal or you're not a criminal. And it's bad to be a criminal. And so if you can get the criminality thing on your political opponent, it helps you win an election. So it's a political tactic. And it's a political tactic on the expertise issue too. You try to have a valence answer. The experts say this, but really what's going on is that there's a political answer that those experts happen to also agree on the politics. And the experts that don't agree on those politics, maybe they understand the data just as well and they have just as much expertise, but then it becomes a political game where expertise now is the hockey puck that's going back and forth rhetorically, even though that's not really what's driving the show. It's not purely about expertise. There's politics involved. Politics because there's different interests involved. Now, I don't know what they would be about squirrels, but it's possible. I mean, if you dug in there, you might be able to find different interests about that. Um, I think it's a lot easier to see about Medicare and anything having to do with health and human services because that's fraught with difficulties in politics. Still more. Well, I want to say one more thing. Congress knows that the Health Department of Health and Human Services can do all those things and courts cannot. Now, here's an ironic thing here. I'm looking at my notes. I make these comments in my notes when I print this out. Um, my comment is, and yet the court itself came up with Chevron deference. That's the ironic thing. The court itself came up with that. Congress didn't come up with that. The court came up with that. She's defending not what Congress did, but what the court did in Chevron, the 1984 case. Still more, Chevron's presumption reflects that resolving, I'm on page 11 now at the top, that resolving statutory ambiguities, as Congress well knows, is often more a question of policy than of law. The task is less one of construing a text than of balancing competing goals and values. Um, this this language of policy and law is sometimes confusing to figure out what a judge means by those terms. Congress creates law. That's the product of all legislative powers here and granted shall be vested in a Congress which shall consist of a Senate and a House of Representatives. Congress creates law, and the law reflects a policy preference. So law is oftentimes policy. So it's confusing when you say policy versus law. What are you talking about? I think here she means policy generated by the executive branch, which has the force of law. So it gets really confusing. Um, I'm just pointing this out. I don't think that she really realizes, or maybe she's taking a lot for granted here about what the assumptions are or should be. Consider the statutory directive to achieve substantial restoration of the natural quiet. Someone is going to have to decide exactly what that statute means for air traffic over the canyon. Let's scroll back up to page 5, 6. Um, Here it is. It's on page 6. It's the third bullet point on page 6. That's where she's talking about right now. Okay. Scroll back down to page 11. Just in case you need to be refreshed by the Grand Canyon example that she's giving. Someone is going to have to decide. Well, yeah, I mean, everybody who tries to comply with the law has to decide what it means. I mean, take a stupid example. Take driving a car. You're going to have to know what a stop sign means. Everybody has to decide that. Everybody who tries to comply with the law has to decide what it is you're confronted with means. The stop sign example I'm giving is just because if you look at the stop sign, it says stop. It doesn't say stop and then go. It doesn't say that. It says stop. That's all it says. So if you just sat there, stopped, you'd probably eventually get a ticket for obstructing traffic if there's nothing wrong with your car. Even though it doesn't say stop and go. You have to understand what it means, the law. Everybody has someone, she says someone's going to have to decide. Well, everybody has to decide that. Everybody. When it impinges on private action, everybody that is underneath that action has to decide. Of course, if you're talking about how a law guides public actors, yes, those people are going to have to decide that too. They're going to have constraints placed upon them by statutes as well. How many flights in what places and at what times are consistent with restoring enough natural quiet on the ground? That is a policy trade-off. Well, hold on a second. Why can't Congress say what that is? Is it just not practical for Congress to decide that? Well, maybe Congress shouldn't be saying anything about this. Or if they didn't say anything, maybe they can't, maybe they can't, you know? What I keep getting to here is the issue of delegation. That the issue of delegation is the elephant in the room here, and you can't avoid it. You cannot avoid the issue of delegation. She says that is a policy trade-off. Well, hold on. Every statute is a policy trade-off. Every law is a policy trade-off. Every single one. Every single law involves balancing competing goals and values. Every single law. It's not just policies, it's laws that are doing that. And judges do that too, sometimes inappropriately in Second Amendment cases, for example, as you've heard me say ad nauseum. There's a policy trade-off of a familiar kind, kind familiar to agencies, but particularly unsuited to judges. Yeah, it's ironic that she's saying that because she's for policy trade-offs when it comes to the Second Amendment. She's for interest balancing there. Yeah, the Republicans aren't, thank God, on the court, but the Democrats are. Or consider Chevron itself, she says. As the court there understood, the choice between defining a statutory source as a whole plant or as a pollution emitting device is a choice about how to reconcile two manifestly competing interests. The plant-wide definition relaxes the permitting requirement in the interest of promoting economic growth. The device-specific definition strengthens that requirement to better reduce air pollution at the expense of economic growth. She should have said, but she didn't. Yeah, it's a choice Congress could have made, but didn't, is the way I would say it. Again, that is a choice a judge should not be making, but one an agency properly can. Under the Constitution, it can. It's a choice Congress could have made, but didn't. Agencies, now remember, she's meaning executive branch. The executive branch are subject to the supervision of the president. By the way, that's the entire theme of the Scalia Dissent series we're doing. Agencies are subject to the supervision of president. So when faced with a statutory ambiguity, an agency to which Congress has delegated policymaking responsibilities may rely on an accountable actor's views of wise policy to inform its judgments. None of this is to say that deference to agencies is always appropriate. The court, I forgot to say something. I hinted at it, but I have one more note that I want to mention. And she says that agencies are subject to the supervision of the president. That sounds like the unitary executive to me. That sounds like the uh, Scalia's dissent in Morrison versus Olson to me. The executive power shall be vested in a president of the United States of America. He shall hold his office during a term of 4 years. Oh, well, there you go. Section 1, Article 2. That sounds like supervision of the president. That sounds like the unitary executive to me. No? Am I wrong about that? None of this to say that deference to agencies is always appropriate. The court over time has fine-tuned the Chevron regime to deny deference in classes of cases in which Congress has no reason to prefer an agency to a court. The majority treats those refinements as a flaw in the scheme, but they are anything but. Consider the rule that an agency gets no deference when construing a statute it is not responsible for administering. Well, of course not. If Congress has not put an agency in charge of implementing a statute, Congress would not have given the agency a special role in its construction. In its construction? I thought Congress is supposed to construct statutes. Or take the rule that an agency will not receive deference if it has reached its decision without using properly its rulemaking or adjudicatory authority. Again, that should not be surprising. Congress expects that authoritative pronouncements on a law's meaning will come from the procedures it has enacted to foster fairness and deliberation in agency decision making. Or finally, think of the extraordinary cases involving questions of vast economic and political significance, which the court has declined to defer. The theory is that Congress would not have left matters of such import to an agency, but would instead have insisted on maintaining control. So the Chevron refinements proceed from the same place as the original doctrine. Taken together, they give interpretive primacy to the agency when, but only when, it is acting as Congress specified in the heartland of its delegated authority. There's the issue of delegation right there. She's saying yes, there's delegation of legislative authority. That's what she's saying. So that's the crux of the matter right there, is whether that's really possible, is whether there's delegated legislative authority to the executive branch. Thanks for joining me on the Republican Professor podcast. We're most of the way through page 12 in the slip opinion of Kagan's dissent in Loper Bright, 2024. Today is 3 April 2025. It is a Thursday. Take care.